world of maximum security, there is a concept called the wall. It is the physical barrier between those who follow the rules and those who are broken by them. But in the digital age, the wall isn't made of concrete and razor wire, it's made of non-disclosure agreements, high-priced lawyers, and the strategic silence of the global elite. For a decade, we were told the Jeffrey Epstein files were a myth, a collection of half-truths and internet conspiracy theories designed to destabilize the powerful. But in early 2026, the digital gates were finally kicked open. Under the pressure of the Transparency Act, the Department of Justice released over 3 million documents directly from the private servers and personal accounts of Jeffrey Epstein. This was the raw data. It didn't just tell the story of a predator, it provided a blueprint for the rule of zero, a systemic reality where the law is a vertical line that gets thinner the higher you climb, until, at the very top, it disappears entirely. The data trail is visceral. It starts with the man who wants to colonize Mars, Elon Musk. Despite years of public denials and calling Jeffrey Epstein a creep, the unsealed emails from 2012 reveal a different reality. What day or night will be the wildest party on your island? Musk asked Epstein in November of that year. By Christmas morning, he was emailing again, claiming to be working to the edge of sanity and begging Epstein to let him loose in the very places he later claimed to have never visited. But the rut goes deeper than tech moguls. It reaches the highest levels of the current administration. U.S. Commerce Secretary Howard Lutnick, a man who claimed to have cut ties with Epstein in 2005, is now caught in the crosshairs of his own family's vacation logs, admitting to the Senate in February 2026 that he did, in fact, have lunch on Jeffrey Epstein's island years after his supposed exit. From the coded language of pizza and snacks used to mask the movement of women from Ukraine and Moldova, to the unredacted files confirming victims as young as 9 years old, this isn't just a case study in crime. This is a look at the machine Jeffrey Epstein built to protect the powerful. This is the raw evidence of a world where love is a transaction, drugs are a tool of control, and the people at the top believe the rules simply do not apply.
If you enjoy real, gripping prison documentaries and true stories, don't forget to like this video, leave a comment, and share it with your friends and family. Hit that subscribe button and turn on notifications so you never miss more shocking and exclusive content.
There is an island in the Caribbean that most people will never visit. It sits roughly 70 miles east of St. Thomas in the United States Virgin Islands, a 72-acre private estate that its owner named Little St. James. Locals had another name for it. They called it Pedophile Island. They had been calling it that for years before the rest of the world caught up. This is not a conspiracy theory. This is a federal case. The documents that prove what happened there have been accumulating in courtrooms, FBI filing cabinets, and sealed judicial records for more than 2 decades. What you are about to hear is drawn entirely from those records, verified court filings, sworn depositions, FBI investigative files, and the groundbreaking journalism that forced the story into the open at a time when powerful people were spending enormous resources to keep it buried. Jeffrey Edward Epstein was born in Brooklyn in 1953. He was gifted at exactly one thing above all others, making powerful men feel he was indispensable to them. He dropped out of Cooper Union, talked his way into a teaching position at the elite Dalton School in Manhattan, and leveraged a single introduction, to Bear Stearns banker Alan Greenberg, into a career managing money for the ultra-wealthy. By the late 1980s he had launched J. Epstein & Company, which he described publicly as serving only clients with a net worth of $1 billion or more. No one could fully verify his client list. No one could explain where his own wealth came from. That opacity was not accidental. It was the architectural foundation of everything that followed. The man who gave Epstein his most important social credential was Leslie Wexner, the billionaire founder of L Brands, the retail empire behind Victoria's Secret and Bath & Body Works. In the late 1980s, Wexner granted Epstein an extraordinary and nearly unprecedented level of financial control, a power of attorney so broad that Epstein could buy property, sign checks, hire staff, and make financial decisions entirely in Wexner's name. It was through this relationship that Epstein acquired his 9-story Manhattan townhouse on East 71st Street, one of the largest private residences in New York City. It was through Wexner's social world that Epstein gained access to the circles of philanthropy, finance, science, and politics that would define his network for the next 3 decades. Wexner would later say he had been defrauded by Epstein and deeply regretted the relationship. But the door that Wexner opened could not be closed again. The townhouse on East 71st Street was not merely a home. According to court filings and victim testimony entered into the federal record, it was a place where young women and girls were brought under the guise of job interviews, modeling opportunities, and educational mentorships. Victims described being recruited by other young women, women who had themselves been victimized and were now used as recruiters. They described arriving at the townhouse expecting a legitimate appointment and instead being directed to give massages that escalated into sexual abuse. This pattern, the use of a legitimate-seeming facade to mask criminal conduct, would repeat itself across every property Epstein owned, from New York to Palm Beach to New Mexico to the Virgin Islands. The Palm Beach estate was where law enforcement first caught up with Epstein. In 2005, the mother of a 14-year-old girl walked into the Palm Beach Police Department and filed a complaint. Detective Joseph Recari was assigned the case. What began as a single complaint expanded into an investigation that would eventually identify more than 30 underage victims in Palm Beach County alone. Recari and his colleagues built a meticulous case. They documented a recruitment network that targeted vulnerable young women, girls from broken homes, girls with financial need, girls who were told they could earn money for a simple massage. The abuse was systematic. It was organized. And it was happening in one of the wealthiest zip codes in the United States, behind the walls of a mansion on El Brillo Way, while Epstein socialized openly with the most powerful people in the country. What Palm Beach police did not know yet, what would take years of legal fighting to fully expose, was that the case they were building was about to collide with a wall of legal and political protection that almost no criminal defendant in American history has ever been able to construct. That wall had a name. It was called the Non-Prosecution Agreement of 2008. In 2007, the FBI opened its own investigation into Epstein, widening the scope far beyond Palm Beach. Federal investigators identified potentially dozens of victims across multiple states. They built what prosecutors themselves later described as one of the most powerful cases of serial sexual abuse of minors they had ever assembled. The recommended charge was a federal indictment that could have resulted in life imprisonment. What Epstein received instead was a deal that has since become one of the most scrutinized and condemned prosecutorial decisions in modern American legal history. Alexander Acosta was the United States Attorney for the Southern District of Florida. He negotiated a non-prosecution agreement with Epstein's legal team, a team that included some of the most prominent defense attorneys in the country, among them Kenneth Starr, the former independent counsel who had investigated President Clinton, and Alan Dershowitz, the Harvard law professor. The agreement allowed Epstein to plead guilty to 2 state charges, solicitation of prostitution and procurement of a minor for prostitution, and serve 18 months in a Palm Beach County jail. He was permitted to leave the jail on work release 6 days a week, 12 hours a day. The federal investigation was closed. The victims were not informed that the deal had been made, in what a federal judge later ruled was a violation of the Crime Victims' Rights Act. Dozens of potential victims who had cooperated with federal investigators were left without justice, without notification, and without explanation. Acosta would later claim he had been told to back off, that Epstein belonged to intelligence and was above his pay grade. That claim has never been fully verified or officially confirmed. But it introduced a question that would follow this case for years. Who, exactly, was protecting Jeffrey Epstein, and why? The non-prosecution agreement did not end Epstein's behavior. It did not end his social life. It did not end his access to power. During the very period of his 18-month sentence, Epstein continued to receive visitors at his Palm Beach home during work release hours. He continued to operate his financial management business. And he continued to cultivate relationships with some of the most prominent figures in science, politics, finance, and philanthropy in the world. His Black Contact book, later obtained by journalist Vicky Ward and entered into the legal record through related court proceedings, contained the private numbers of presidents, prime ministers, Nobel laureates, Hollywood figures, and royalty. Among the most documented relationships in Epstein's network was his long association with Prince Andrew, the Duke of York and son of Queen Elizabeth II. Virginia Giuffre, one of Epstein's most prominent accusers, stated under oath in a 2015 deposition that she had been trafficked to Prince Andrew on 3 occasions, beginning when she was 17 years old. She described being recruited by Ghislaine Maxwell at Mar-a-Lago at the age of 16, becoming Epstein's personal assistant and abuse victim, and being directed to have sexual contact with Prince Andrew in London, in New York, and on Epstein's private island. Prince Andrew has categorically denied these allegations. In 2022, he settled a civil lawsuit brought by Giuffre for an undisclosed sum without admitting liability. The settlement itself, and the terms under which it was reached, became part of the public record. Ghislaine Maxwell was not a peripheral figure in this story. She was, by the account of victims, prosecutors, and the jury that convicted her in December 2021, the central operational figure in Epstein's abuse network. The daughter of the British media baron Robert Maxwell, she had met Epstein in the early 1990s and became his companion, his social fixer, and according to federal prosecutors, his primary recruiter and groomer of underage victims. Maxwell was convicted on 5 of 6 federal counts, including sex trafficking of a minor and conspiracy. She was sentenced to 20 years in federal prison. Her conviction was the clearest legal confirmation that what Epstein operated was not the behavior of a lone predator but a structured, organized criminal enterprise with multiple participants. The flight logs from Epstein's private aircraft, a Boeing 727 that victims and press dubbed the Lolita Express, were entered into the legal record through civil litigation and FOIA requests. Those logs documented hundreds of flights carrying a roster of passengers whose names read like an index of global power. Former President Bill Clinton was documented on the flight logs more than 24 times, traveling to various Epstein properties. Clinton has stated he knew nothing of Epstein's crimes and that his trips involved humanitarian work. Former President Donald Trump was a documented social acquaintance of Epstein's in New York during the 1980s and 1990s, and was quoted in a 2002 New York Magazine profile describing Epstein as a terrific guy who enjoyed beautiful women as much as he did. Trump has since stated he had a falling out with Epstein years before the criminal investigations began. The flight logs alone do not constitute evidence of criminal conduct by any passenger, but they document something undeniable, that Epstein's world was not a secret underworld. It was the world. It was dinner parties and galas and scientific conferences and private jets and the social infrastructure of global power. The question that the flight logs, the court filings, the FBI records, and the victim testimonies all point toward, the question that this documentary exists to pursue, is not simply what Jeffrey Epstein did. We know what he did. He was convicted. His co-conspirator was convicted. The victims have told their stories under oath and in public, at enormous personal cost. The question is how? How did a man with no verifiable source of legitimate income accumulate 9 properties across 4 countries, a private island, a private Boeing 727, and a social network that encompassed heads of state? How did a man who was the subject of a federal criminal investigation that prosecutors described as overwhelming receive a deal that allowed him to avoid federal prison entirely? How did the same man, after that deal, continue to move freely through the highest levels of society for another 11 years before finally being arrested by federal agents in July 2019? And how, on August 10th of that year, 6 weeks after his arrest on federal sex trafficking charges, did Jeffrey Epstein die in a federal detention facility in Manhattan while supposedly under suicide watch, a facility where the security cameras outside his cell malfunctioned, his cellmate had been transferred, and the 2 guards assigned to check on him every 30 minutes had both fallen asleep. The medical examiner ruled his death a suicide by hanging. The forensic pathologist hired by Epstein's legal team and brother, Dr. Michael Baden, reviewed the same evidence and concluded that the injuries were more consistent with homicide. No definitive resolution of that contradiction has ever been officially reached. What we are left with is the record. Not speculation, not theory. The record. Thousands of pages of court filings. Hundreds of hours of sworn depositions. Victim impact statements delivered in open court. A convicted co-conspirator currently serving a 20-year sentence. Flight logs. Property records. A contact book. A non-prosecution agreement that a federal judge ruled violated the law. And a set of questions about money, power, and immunity that the death of Jeffrey Epstein did not answer. That no single arrest, no single conviction, no single documentary can fully answer. But that the record demands we continue to ask. This is Act 1. This is where the story begins. Not with a conspiracy. With a document. With a complaint filed by a mother at a police station in Palm Beach, Florida, in 2005. With a detective named Ricari who followed the evidence wherever it went. With women who told the truth at enormous personal cost and were not believed for years. The illusion of distance, the idea that what happened on that island, in that townhouse, on those flights, was somehow separate from the world the rest of us live in, is the first thing the record destroys. Jeffrey Epstein did not operate in the shadows. He operated in plain sight. And the most important thing the documents tell us is not who was on the island. It is who knew, who looked away, and who made sure the consequences never came. Every criminal enterprise requires infrastructure. Not just money and not just power, infrastructure. Physical spaces. Logistical systems. People who perform specific functions within a chain that is designed, above all else, to protect the person at the top. What made Jeffrey Epstein's operation different from most criminal networks was not its scale, though the scale was vast. It was not its duration, though it ran for decades. What made it different was the precision with which it was engineered to look like something else entirely. To look like philanthropy. To look like mentorship. To look like the entirely ordinary social world of extraordinary people. The infrastructure of Epstein's network was hidden inside the infrastructure of respectability itself. And to understand how it worked, you have to understand the recruitment. It did not begin on a private island. It did not begin on a private jet. It began in the most ordinary places imaginable. In high school hallways, in shopping malls, in public parks, in the waiting rooms of modeling agencies. It began with a conversation between a young woman who needed money and another young woman who said she knew how to get it. The recruitment model that federal prosecutors and FBI investigators documented across multiple years of investigation followed a pattern so consistent that investigators came to treat it as a signature. A young woman, typically between the ages of 14 and 17, typically from a financially unstable background, typically without a strong adult support network, would be approached by a female recruiter who was approximately her own age or only slightly older. The recruiter would describe a wealthy, well-connected man who paid generously for simple services. A massage. A conversation. The chance to make a connection that could change your life. The initial approach was carefully calibrated to match the specific vulnerabilities of each target. For a girl who needed rent money, the pitch was financial. For a girl who wanted to be a model, the pitch was opportunity. For a girl who had academic ambitions, the pitch was access to a powerful man who funded scientific research and could open doors. The pitch was never the truth. The pitch was always a mirror held up to what the target most wanted to believe was possible. This method, using peer recruiters, using the language of opportunity, using the existing aspirations of vulnerable young women against them, is described in clinical criminological literature as a luring technique. It is distinct from forcible abduction. It is designed to produce consent that is not consent, cooperation that is not cooperation, a choice that is not a choice. The girls who walked through Epstein's doors believed they were walking toward something. The federal record shows they were walking into something, a system that had been engineered specifically to receive them. Ghislaine Maxwell was, according to the evidence presented at her federal trial, the architect and primary operator of that system. Born in France in 1961, the youngest daughter of the British media magnate Robert Maxwell, she had grown up in a world of extraordinary privilege and extraordinary dysfunction. Her father was a fraudster on a colossal scale, a man who stole hundreds of millions of pounds from the pension funds of his own employees before dying in mysterious circumstances in 1991, found floating in the ocean near his yacht off the Canary Islands. Ghislaine Maxwell arrived in New York shortly after her father's death, reportedly near bankruptcy, and reconnected with Epstein, whom she had known socially in London. Their relationship, romantic at first, then evolving into something more operational, would last for the better part of 3 decades. She brought him social access to British aristocracy and European money. He gave her a platform, properties to live in, and a role. That role, as the jury at her federal trial determined beyond a reasonable doubt, was the grooming and trafficking of underage girls. At trial, prosecutors presented a detailed picture of how Maxwell operated. She would identify potential recruits, often through scouts or through Epstein's existing social network, and begin a process of normalization. She would befriend the girls. She would take them shopping. She would ask them about their lives, their ambitions, their families. She made them feel seen and valued by a sophisticated, worldly woman who seemed to genuinely care about them. Prosecutors called this grooming. The psychological literature on grooming describes it as the systematic dismantling of a victim's natural boundaries through the gradual escalation of intimacy and trust, until behaviors that would initially have been refused feel normalized and even desired. Maxwell was, by the testimony of multiple victims heard at trial, exceptionally skilled at this process. The transition from grooming to abuse followed a pattern that multiple victims described in nearly identical terms. Maxwell would be present at the initial massage sessions. She would normalize the nudity, the physical contact, the escalating nature of what was being asked. She framed abuse as ordinary, as professional, as something that powerful people in sophisticated social worlds simply did. Several victims testified that Maxwell participated directly in the abuse. Maxwell denied all of it. The jury did not believe her. But Maxwell and the recruiters she managed could not have operated without physical infrastructure. And that infrastructure was extensive, deliberate, and maintained across multiple jurisdictions simultaneously. The Manhattan townhouse on East 71st Street was the epicenter of the New York operation. The Palm Beach estate on El Brillo Way was the Florida base. The Zorro Ranch in Stanley, New Mexico, a 7,500-acre property in the high desert, was documented in victim testimony and investigative records as another site of abuse. And then there was the island. Little St. James had been purchased by Epstein in 1998 for approximately $7.9 million. By the time investigators began documenting what occurred there, he had spent tens of millions more transforming it. There was a main residence. There were guest cottages. There were staff quarters. There was a building that witnesses described as a temple, a blue and white structure with a distinctive gold dome that appeared in aerial photographs and that Epstein himself referenced in communications. The purpose of that structure has never been fully and officially explained. What has been documented, through victim testimony and investigative records, is that the island functioned as the most controlled, most isolated, and most protected site in Epstein's entire operation. It was, in the most literal sense, a place where the normal rules did not apply, because it existed in a jurisdiction where Epstein had cultivated relationships with local officials and where the physical isolation made oversight nearly impossible. The United States Virgin Islands government's relationship with Epstein is a documented part of the legal record. Epstein had received substantial tax incentives from the Virgin Islands Economic Development Commission, incentives that were later scrutinized and ultimately clawed back through litigation. The Virgin Islands Attorney General filed suit against Epstein's estate after his death, seeking the return of tax benefits that had been granted to his Southern Trust Company, a Virgin Islands registered entity whose stated purpose, technology and data services, bore, investigators concluded, no meaningful relationship to its actual function. That litigation resulted in a settlement of over $105 million paid by the Epstein estate to the government of the Virgin Islands. The money that funded all of this, the island, the townhouse, the ranch, the Manhattan mansion, the Boeing 727, the staff across multiple properties, the legal fees, the political donations, has never been fully and satisfactorily explained. This is not a minor footnote to the story. It is arguably the central mystery. Epstein claimed to manage money for billionaires. He claimed a client minimum of $1 billion in net worth. Outside of his relationship with Leslie Wexner, no major client has ever been publicly identified and confirmed. No audited financial records of J. Epstein and Company have ever entered the public domain. Forensic financial investigators who examined the estate after his death found a structure of extraordinary complexity: shell companies, offshore accounts, real estate holdings spread across multiple jurisdictions, that appeared, in the assessment of those investigators, less like the portfolio of a legitimate financial manager and more like the financial architecture of a blackmail operation. That word, blackmail, appears in the legal and investigative record not as theory but as documented allegation. Maria Farmer, one of the first women to report Epstein to the FBI, stated in interviews that Epstein had told her directly that he collected information on powerful people as a form of insurance. Virginia Giuffre's civil complaint alleged that she had been directed to have sexual contact with powerful men for the explicit purpose of gathering compromising information. The installation of cameras throughout Epstein's properties, documented in victim testimony and referenced in investigative records, raises questions that the official record has not fully answered about whether the abuse was recorded, and if so, where those recordings are. The question of recordings intersects directly with the question of intelligence. Epstein cultivated relationships with figures from the intelligence communities of multiple countries over many years. His relationship with Abe Barak, the former Prime Minister and Defense Minister of Israel, was documented, publicly acknowledged by Barak himself, and the subject of significant investigative journalism. Barak stated that he had visited Epstein's New York properties on multiple occasions, though he denied knowledge of or participation in any criminal activity. What the nature of their relationship was beyond the social and financial, Epstein had invested in at least one technology venture associated with Barak, has not been officially established. But the intelligence question is not limited to any single country or any single relationship. Robert Maxwell, Ghislaine's father, was widely believed by intelligence analysts and journalists who covered him to have had relationships with multiple intelligence services, including Mossad. Whether those relationships extended through his daughter to Epstein is a question the record raises but does not definitively answer. What the record does answer, clearly, legally, finally, is the question of whether what Epstein operated was a criminal enterprise. It was. What it answers about the recruitment of underage girls is that it was systematic, organized, multi-jurisdictional, and sustained over decades. What it answers about the role of Ghislaine Maxwell is that she was not a bystander. She was a principal. What it answers about the legal system's initial response is that it failed, comprehensively and in ways that a federal judge officially confirmed were illegal. What it does not yet fully answer is the scale. The Maxwell trial convicted her on charges related to 4 victims. The broader federal investigation identified many more. Civil litigation has produced settlements with dozens of claimants. The full scope of how many young women and girls were victimized across how many years and how many properties remains, in the official record, incomplete. This is in part because Epstein is dead. It is in part because Maxwell has maintained her silence about the broader network. It is in part because the Non-Prosecution Agreement of 2008 effectively shut down a federal investigation that prosecutors believed was only beginning to approach the full dimensions of what had occurred. The women who came forward did so knowing they would be disbelieved. They came forward knowing their pasts would be examined, their credibility challenged, their motivations questioned. They came forward anyway, to Palm Beach detectives, to FBI agents, to civil attorneys, to journalists, ultimately to federal juries. Annie Farmer, Maria Farmer, Virginia Giuffre, Tila Davies. The 4 women whose testimony formed the core of the Maxwell prosecution, whose names were used at trial only as Jane. They gave their accounts under oath, in detail, consistently, and at cost to themselves that most of us will never be asked to bear. The infrastructure of Epstein's operation was built to make them feel alone, to make them feel complicit, to make them feel that no one would believe them over the word of a man who had dinner with presidents. The infrastructure failed. Not quickly enough. Not before enormous harm was done. But it failed. And the record that failure produced is what we have now. It is what this documentary is built on. It is what Act 2 is about, not the powerful men at the top of the network, but the machinery below them. The recruiters. The properties. The financial architecture. The legal protection. The system that was built, piece by deliberate piece, to make the abuse possible and to make accountability impossible. A system that, for nearly 2 decades, worked exactly as designed. Immunity is not an accident. It does not happen because powerful people are lucky. It does not happen because the system fails through incompetence alone, though incompetence plays its role. Immunity, at the scale that Jeffrey Epstein enjoyed it, is constructed. It is built the way a building is built, Deliberately, expensively, with specific materials chosen for specific load-bearing purposes, by people who understand exactly what they are doing and why. The architecture of Epstein's immunity was decades in the making. It involved lawyers and prosecutors and politicians and financiers and intelligence figures and local officials across multiple jurisdictions on multiple continents. And when it finally collapsed, partially, incompletely, too late for too many, it collapsed not because the system caught up with Jeffrey Epstein. It collapsed because a small number of individuals refused to let the system keep its silence. Understanding how the immunity was built requires going back to the beginning of it. Not to the island. Not to the townhouse. To a courthouse in Palm Beach, Florida, in 2007, where the most consequential prosecutorial decision in this entire story was made. When the Palm Beach Police Department completed its investigation in 2006 and referred the case to the state attorney's office, the evidence they submitted was, by any standard measure, overwhelming. They had identified more than 30 underage victims in Palm Beach County alone. They had documented a recruitment network. They had recorded phone calls. They had victim statements that corroborated one another in specific detail across dozens of interviews conducted independently. State Attorney Barry Krischer reviewed the evidence and chose to present it to a grand jury, but the manner in which he presented it produced a single felony count of unlawful sexual activity with a minor. Epstein's attorneys moved aggressively and the case was transferred to federal jurisdiction, where U.S. Attorney Alexander Acosta took over. And it was there, in federal jurisdiction, where the first and most consequential pillar of Epstein's immunity was formally constructed and signed into law. The non-prosecution agreement that Alexander Acosta negotiated in 2008 has been examined, dissected, and condemned by legal scholars, former prosecutors, victims' rights advocates, and a federal judge. But to understand what made it so extraordinary, what made it, in the words of Judge Kenneth Morris' 2019 ruling, a violation of the Crime Victims' Rights Act, you have to understand what was traded away. Federal prosecutors had built a case identifying Epstein as the central figure in a criminal enterprise that had victimized dozens of underage girls across multiple states. The recommended charges included federal sex trafficking offenses that carried potential sentences of life imprisonment. What Epstein received in exchange for his guilty plea to 2 state-level charges was an 18-month sentence in a county jail, not a federal prison, with work release privileges that allowed him to leave 6 days a week. He registered as a sex offender. He paid restitution to identified victims. And the federal investigation was closed. Not paused. Closed. Every potential federal co-conspirator, every person who might have been identified and charged as part of the broader trafficking network, received immunity from federal prosecution under the terms of the agreement. The victims were not told the agreement had been reached. They were not given the opportunity to provide input. This was not an oversight. Judge Morris' ruling found that prosecutors had deliberately concealed the agreement from victims in violation of their statutory rights. The agreement was negotiated in secret over a period of more than a year, during which Epstein's legal team, which included some of the most prominent defense attorneys in the country, maintained direct communication with federal prosecutors. Alan Dershowitz, the Harvard law professor who was part of Epstein's legal team, would later become entangled in the civil litigation himself, named as an alleged participant in Epstein's abuse network by Virginia Giuffre. Dershowitz has vehemently and consistently denied those allegations and has pursued his own legal actions in response. Kenneth Starr, the former independent counsel, was also part of the team. The assembly of legal talent that Epstein deployed suggests not just wealth but access to a legal network that understood how federal prosecutions worked from the inside and was positioned to apply pressure at exactly the right points in the process. What drove that pressure? What gave Epstein's legal team the leverage to negotiate an agreement that federal prosecutors would never have offered an ordinary defendant, remains one of the most contested questions in this case. Alexander Acosta, during his 2017 Senate confirmation hearing for Labor Secretary, was asked directly about the agreement. He described it as the product of a difficult case with evidentiary challenges. Legal observers and former federal prosecutors who have reviewed the file have largely rejected that characterization. The evidence, by the accounts of the FBI agents who built it, was not weak. It was, in their assessment, among the strongest cases of serial child sexual abuse they had encountered. The question of what else was operating, what other pressures, what other considerations, what other knowledge was in the room during those negotiations, has not been officially answered. What entered the public conversation was a claim, reported by the journalist Vicky Ward and later repeated in various forms by others, that Acosta had been told during the negotiation process that Epstein was above his pay grade, that Epstein belonged to intelligence. Acosta himself, in a conversation reported by Ward, did not deny having been given this impression. The claim has never been officially confirmed by any government agency. The CIA, the FBI, the Department of Justice, and every intelligence service that has been named in connection with Epstein have either denied a relationship or declined to comment. But the claim exists in the record, and it refuses to disappear, because the documented facts around it, the extraordinary nature of the deal, the secrecy of its negotiation, the scope of what was granted, do not have a satisfying alternative explanation. What is documented, without dispute, is that Epstein's network included individuals with deep ties to the intelligence communities of multiple nations. Abe Barak, former Prime Minister of Israel, former Chief of Staff of the Israel Defense Forces, former Defense Minister, was a documented associate of Epstein's who acknowledged visiting his New York properties. Barak has stated that he invested in a technology venture with Epstein, that he socialized with him, and that he had no knowledge of criminal activity. The investment Barak acknowledged involved a company working in the field of security technology. Robert Maxwell, Ghislaine's father, was the subject of extensive reporting and intelligence community analysis suggesting deep ties to Israeli intelligence, Soviet intelligence, and British intelligence simultaneously, a man described by some analysts as one of the most effective intelligence assets of the 20th century who operated under the cover of a legitimate media empire. Whether the daughter inherited any dimension of those relationships, or whether those relationships shaped in any way the extraordinary protection that Epstein appeared to enjoy, the official record does not confirm. But the official record does not deny it either. And it is the pattern, the consistency of protection, across jurisdictions, across years, across administrations of different political parties, that makes the intelligence question impossible to dismiss. After the 2008 agreement, Epstein returned to his life. This sentence requires sitting with for a moment, because it describes something that should not have been possible and yet was entirely real. A man who had been convicted of soliciting the prostitution of a minor, who had been identified by federal investigators as the central figure in a multi-state child sex trafficking network, returned to his life. He completed his 18 months, with work release. He registered as a sex offender. And then he flew on his private plane to his private island and his Manhattan townhouse and his New Mexico ranch, and he continued to host the scientists and the financiers and the politicians and the royalty who had always come to his properties, and the world that had always received him continued to receive him, with only minor and temporary adjustments. The adjustment period was brief. By 2011, Epstein was photographed at a dinner at the Paris home of a prominent socialite. By 2014, he was hosting scientific conferences at his Manhattan townhouse. By 2015, he was traveling internationally without apparent restriction. The social consequences of a federal sex offender conviction, for a man of Epstein's wealth and connections, amounted to a temporary awkwardness that the passage of time largely resolved. This is not a peripheral observation. It is the mechanism of immunity in its final and most revealing form, not the legal protection that kept him from prison, but the social protection that kept him in the world. The willingness of powerful institutions, universities, research foundations, media organizations, social networks, to continue engaging with a convicted sex offender because his money and his connections remained valuable. Harvard University accepted donations from Epstein after his conviction. MIT's Media Lab, as reporting by the New Yorker's Ronan Farrow later revealed, accepted funding from Epstein after his conviction and went to deliberate lengths to conceal the source of that funding. The institutional accommodation of Epstein after 2008 is its own chapter in the architecture of immunity, and it is a chapter in which the institutions themselves are not blameless. The second legal reckoning came in July 2019, when federal agents arrested Epstein at Teterboro Airport in New Jersey as he returned from France on his private jet. The arrest was made by the Southern District of New York, a different federal jurisdiction from the one that had negotiated the 2008 agreement, and one that had been investigating Epstein independently. The charges were federal sex trafficking of minors and conspiracy to commit sex trafficking. The indictment described a network that had operated from 2002 through 2005, identifying victims who had been recruited from economically vulnerable backgrounds, groomed, abused, and in some cases used to recruit other victims. Prosecutors requested that Epstein be held without bail, describing him as a danger to the community and a significant flight risk given his private aircraft and his properties in jurisdictions that did not have extradition treaties with the United States. A federal judge granted detention pending trial. Epstein was housed at the Metropolitan Correctional Center in Lower Manhattan. It is a federal detention facility. It has federal protocols for the monitoring of high-profile inmates, particularly those facing serious charges and identified as potential suicide risks. Epstein had been placed on suicide watch following an earlier incident in the facility in late July, an incident that was itself the subject of conflicting accounts, with questions raised about whether it was a genuine attempt or something else. He was taken off suicide watch in late July and returned to a regular cell. On August 9, 2019, the two guards assigned to check on Epstein every 30 minutes both fell asleep during their shift and failed to conduct the required checks for approximately 3 hours. The security cameras in the corridor outside Epstein's cell malfunctioned and did not record the relevant time period. Epstein's cellmate had been transferred to another unit. On the morning of August 10, 2019, Jeffrey Epstein was found unresponsive in his cell. He was pronounced dead at New York Presbyterian Lower Manhattan Hospital. He was 66 years old. The official ruling of the New York City medical examiner was suicide by hanging. The forensic pathologist retained by Epstein's brother and legal team, Dr. Michael Baden, one of the most prominent forensic pathologists in the United States, a former New York City chief medical examiner, reviewed the physical evidence and stated publicly that the injuries were more consistent with homicide by strangulation than with suicide by hanging. He specifically referenced fractures in the hyoid bone and other neck structures that he argued were more typically associated with homicidal strangulation. The official medical examiner maintained the suicide ruling. The contradiction between these two expert assessments has never been officially resolved. Two guards who were responsible for monitoring Epstein that night were charged with falsifying prison records, for logging checks that they did not conduct. They subsequently reached deferred prosecution agreements with the government, avoiding prison time. The death of Jeffrey Epstein foreclosed the federal criminal case against him. It did not foreclose the civil cases. And it is through civil litigation, through the lawsuits brought by dozens of survivors against Epstein's estate, against Ghislaine Maxwell, against the financiers and institutions that enabled the network, that additional accountability has been pursued. The Epstein estate, valued at approximately $577 million at the time of his death, has paid settlements to more than 150 claimants through a compensation fund established under the administration of the estate. The settlements are confidential. The amounts are not public. But the scale of the fund and the number of claimants provide, in financial terms, the clearest available measure of the scope of what occurred. Ghislaine Maxwell exhausted her appeals and entered federal prison to serve her 20-year sentence. She has maintained that she was a scapegoat, that she was convicted for crimes that others who were equally or more culpable have never been charged with. The identity of those others, the individuals who visited Epstein's properties, who used the network he and Maxwell maintained, who participated directly in the abuse of the young women and girls who passed through that system, has been the subject of civil litigation, investigative journalism, and public demand for years. The court-ordered release of documents from the civil case Jeffrey versus Maxwell, completed in stages between 2023 and 2024, has put additional names into the public record as individuals mentioned in depositions and court filings. The presence of a name in a court document is not a conviction. It is not an indictment. It is a fact in the record, to be evaluated as part of the record, in context, with the full weight of what the rest of the record shows about how this network operated and who it served. What the full record shows, accumulated across 20 years of police investigations, federal prosecutions, civil litigation, investigative journalism, and survivor testimony, is this: Jeffrey Epstein built a criminal enterprise that sexually exploited dozens, and likely hundreds, of young women and girls over a period of at least 3 decades. He built it inside the social infrastructure of legitimate wealth and power. He protected it through the strategic cultivation of relationships with individuals who had the ability to provide legal, financial, political, and institutional cover. He nearly escaped all legal consequence through a prosecutorial agreement that a federal judge ruled illegal. He died in federal custody under circumstances that remain, in their full dimensions, unexplained. His primary co-conspirator is in federal prison. His estate has paid settlements to more than 150 survivors. And the question of who else bore legal and moral responsibility for what occurred, who enabled it, who participated in it, who protected it, remains, in the official record, incompletely answered. The architecture of immunity was real. It was built by real people making real decisions, in prosecutors' offices and in private law firms, in boardrooms and on private islands, in the offices of universities and research foundations, in the social calculations of people who knew enough to be troubled and chose not to be troubled enough to act. Some of those people have faced consequences. Most have not. The survivors who forced the story into the light did so at enormous cost, against a system that was designed at every level to absorb and neutralize them. They were not absorbed. They were not neutralized. They are the reason the record exists. They are the reason this documentary is possible. And they are the reason that the architecture of immunity, however durable it proved for so long, did not hold forever. This is not the end of the story. In law, in journalism, in the ongoing civil proceedings, in the questions that the official record raises and does not yet answer, the story continues. What we have is not closure. What we have is a record. And the record is enough to know what happened, to know that it was not accidental, to know that it was not inevitable, and to know that the people who stopped it, who refused to be silent, who kept filing, who kept reporting, who kept testifying, made the only choice that the evidence and the survivors required.